only in exceptional cases. Now, why should a lordship have to change this emphasis or even the contours and guidelines? Kindly pause here. I am saying something different. Your lordship has laid down a certain law. My lordship has already cribbed and confined it by such paragraphs. It is not that in every case we just jump up and say group, and a lordship accepts group. So there is sufficient inbuilt safeguards. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of the subject matter, and the agreement between the parties being a composite transaction. These are some of my guidelines, my 16 guidelines. These are some of the criteria. Now, your lordship cannot be asked to crib and confine it in a manner that your lordship is to anticipate all future situations and bring in rigidity and non-flexibility. That's not possible for your lordship. Commercial matters have very, very different contours every future case. Chair. Because I had the occasion to appear in Cheran, my lord heard it. That was a little strange fact. You may not remember this.
It was actually a very strange case, because
in other words,
he had assumed the obligation clearly.
Not only that, I appeared for the losing party whose immediate relation had lost the arbitration award up to the Supreme Court.
Right.
He set up a proxy to challenge the same award all over again. I was appearing for that proxy. Your lordship found him with a proxy. Your lordship found him with a proxy. You were denying it with a proxy, but your lordship found him with a proxy. So that really turns on that. Of course, we were denying it's a proxy. Your lordship found it a matter of fact. And that's how your lordship clears the way. Kindly pause here. I am saying. Original award was lost to the Supreme Court. The new fellow started the ladder all over again. So, here, group companies doctrine applied to pierce the veil. Doctrine of companies is akin to principles of agency or implied consent. Now, C, D.2c. In Cheran, so the lordships relied on bond. The doctrine provides that a non-signatory group may be bound by an arbitration agreement where a group of companies exists and the parties have engaged in conduct. This is where the principal comes in, such as negotiation or performance of the relevant contract, or made statements indicating the intention assessed objectively and in good faith that the non-signatory be bound and benefited by the relevant contracts. While the alter ego principle is a rule of law which disregards the effects of incorporation or separate legal personality, in contrast, the group of companies doctrine is means of identifying the intentions of parties and does not disturb the legal personality of the entities in question. So my lord makes a distinction which is conceptual. In other words, the group companies doctrine is akin to principles of agency or implied consent, whereby the corporate affiliations amongst distinct legal entities provide the foundation for concluding that they were intended to be parties to an agreement, notwithstanding their formal status as non-signatories. Just pause here. Take an actual situation, we do it every day on this side of the bar, and a lordship hears many of those fact situations on that side. Whereas foreign companies come in a clutch of different personalities. The holding company is A in USA. Its Asia regional head is B, located somewhere in Asia. Its India company is C. And when a tender is floated, the bid is by an SPV, which is D. My lord must have had hundreds of cases like that. Now, they are all really, now, in every case, because they are part of a large group, it doesn't pierce the veil and have a group companies. Not that I'm saying that. Now, at the documentation at the beginning of the negotiation, and thereafter, more importantly, in the performance, the SPV may be a shell company. Frequently, it outsources or gets it implemented by the previous company C. The negotiation is entirely done by B and C. Now, your lordships may, in an appropriate case, have necessity to say, look, all of these, well, if a dispute starts and I go only against D, it's a Pyrrhic victory for anybody. I go against only D and I win an award. It's a Pyrrhic victory in many cases. It's a futile. Equally, it doesn't mean that a lordship straight away goes to A. That's not the argument. But your lordship must have play in the joints, flexibility in the joints to decide. Well, the judges ultimately decide by a feel of the case. According to me, feel of the case is the most important. There, your lordship then goes into details. Now, the feel of the case requires justice to be done. Your lordship is told strictly there is no doctrine, or the doctrine is so circumscribed that you will not go beyond D. That will cause injustice. That is not. And something which is not new. Your lordship has got it 10, 12 years in India and much before that abroad. Why should your lordship crib it, confine it more, or indeed abolish it? That's the question. In this group, your lordships needs awards not to be Pyrrhic. Well, sometimes they say that the evidence will not be there if you don't have other parties. Sometimes you say that witnesses will not be there if you don't have other parties. That flexibility has to be there. Just to say, one of the arguments is that this group doctrine is only in 2 or 3 countries.
The flip side of
India,
the flip side of flexibility is uncertainty.
No, I'm coming to that. Now, uncertainty. Suppose this same example I've given, the contract makes it clear in 2 crystal clear clauses of great comprehensiveness that the parties from the inception know that this is being negotiated and performed by D or rather by C, but the SPV is D. And under no circumstances shall there be any liability, any suability, any involvement of C. That will be an important exculpatory circumstance, even there is not binding on a lordship. It will be an important clue to the intention of parties. The intention of parties the lordship is searching for. That intention may come from a letter. What is referred to as uncertainty is also going to play in the joints.
Suppose the conduct of the parties are such, and yet they have a letter written by the principal A that we are nothing to do with this contract. But then they have conducted themselves in a manner which would suggest that they have actively participated.
Exactly.
Then that letter, would that be a defense?
No, that's the point I'm making. It is all in the common hodgepodge of your lordships gleaning the intention. In the common hodgepodge, your lordship finds that everything is done from breach, from performance, from negotiation, from implementation by X. But X has written a letter, look, I'm out. I'm not liable. No. Your lordship will go by the overall conduct of the case. That one letter will not escalate. However, if from the inception there are repeated letters saying that, look, this is the position we have put not 1 but 2 companies, then it will be one of the clues to intention, not dispositive. The answer by Lord is very not dispositive, not binding, but it will be one of the clues to intention of the parties, which is paramount. Ultimately, the reality, the real point of this doctrine is the reality to do justice has to be seen, not the formality. And your lordships should not, according to me, worry or be anxious about the fact that your lordships can never in any principle anticipate all the myriad cases or situations. Within the existing 16 principles, or any more principle your lordship may add, how is it possible that somebody will get injustice because your lordship has ample principles here?
There is some problems.
Yeah. Chetan. Arbitration.
Because you are wanting an interpretation which is justice-oriented interpretation. Because this is not in the realm of public law. My fundamental problem with this is not in the realm of public law. This is purely a private remedy, purely and absolutely private remedy. Looked at in that context, section 6 has to be interpreted. Section 7 has to be interpreted. Means an agreement between the parties coupled with the subsequent sections very specifically saying that there must be a written agreement. agreement between signatories. So the contract, the requires of the statute in arbitration law as against what we have in a civil court where there is a remedy available to anybody publicly provided, or compare with 226 or 32. These are public remedies as against a private remedy. So when we talk about a private remedy, it must be strictly an agreement between the parties. And to say an agreement between parties can be parties, open-ended parties. And the court will from time to time, case to case, will decide on the facts of a case, who will be the parties, who will not be the parties, depending upon public requirement and justice between the parties on a larger perspective will create a lot of problems. Because number one, every stage of section 11, you are expecting the court to do an inquiry whether justice requires a party to be brought in or not.
No, let me explain. I'm grateful.
Only consideration so far as contracts are concerned are if it is hit by public policy. Yes, of course, courts can
So
intervene.
that, let me, Malas, I'm very grateful for the query. Let me just expand on this. This helps me to clarify. Number one, I am not at all saying that your lordship will or will not apply group doctrine on the basis of justice. Please take that as given. I'll put it, lordship will note it down in my submission. That's not at all. And that would be too wide, too open-ended, and it would be actually causative of injustice. What am I saying? I'm saying 2 or 3 basic points. 1. 7, for example, your lordship mentioned, which is dealt with in my later section E. There are 7 along with 3 or 4 other sections, which I've cited in my section E, are actually indicative of expansion beyond parties in the traditional sense. Not indicative of limitation, but of expansion. In the old pre-96 era, your lordship would have more easily looked at only signatories or bilateral, trilateral contracting signing parties. Take, for example, I'm giving a much larger answer, I'm just reacting to the 7 your lordship mentioned. Take, for example, B and C of 7. The idea, in fact, is to expand it immeasurably, which could never be thought of by a 1940 Act practitioner. Non-signing parties, non-parties to a contract, who are evidencing a relationship to be bound by an exchange of documents or an exchange of pleadings. I'm doing a running paraphrase.
You're right. You're right.
Now,
But the problem is that 7.4b and 7.4c, actually 7.4a, 7.4b and 7.4c
yes.
are all indicative of the fact that though the arbitration clause may not be in the parent contract, so to speak, it yet has to emerge from a course of written dealings between the parties, right? Therefore, in a document signed by the parties, an exchange of letters, an exchange of statements of claim and defense. So all of them, A, B, and C, are instances of a written commitment.
Parties.
Now, what we are trying to explore is whether the extension of the arbitration agreement can take place by a conduct of a party in, say, supporting the contract or implementing a contract, a parent, in relation to a subsidiary, so on and so forth. That can we really contemplate when 2 things. 737 arbitration agreement shall be in writing. Therefore, if you impose this now if you interpose this in certain one, it means arbitration agreement means a written agreement by the party all or certain disputes which have arisen or which may arise between them. Now, between them means whom? The parties to them means the parties to the agreement. Now, parties to what? Parties to the written agreement. I mean, if you take a literal construction of this, therefore, them would mean the parties to the agreement. Which agreement? The written agreement. It can be expanded to include, say, a statement of claim and defense. But then again, it's parties to the agreement.
So, really, who are parties? Who are parties? Who are parties is one of the core questions. Give me just 2 minutes.
And though none of the judgments has considered it, you may also consider it from another point of view of Section 91 of the Evidence Act.
Yes.
See, because once you have a written contract, then any oral evidence to establish the terms of the contract for adding to the terms of the contract is inadmissible under our law. 91 and 92 come in the way.
Correct. Well, first of all, let me take it. A interpretation.
You're right about, on the first part, you need not really elaborate the desirability, the fact that
No,
Fluoro
coming to the
has been in
legal-
the field for 10 years.
No.
That absolutely, as a matter of commercial wisdom.
Yes.
As a matter of fact, otherwise what will happen according to you is that you will set up only a shell company and the person behind the shell company will go scot-free. We see all that point. That's all the, but then we now have to find some textual grounding.
That's-
Yes,
That's the point.
Just continuing from what Honorable Chief Justice has said, the play that we have from the previous regime, if you compare both the sections, section 7 and the section under 1940, of course, there is definitely some amount of expansion. So the fluoro control and the subsequent progeny, as you call them, will have to be fitted within section 7, expanded, and no further.
Of course.
No further, you can't go further. So therefore, to say justice orientation, so therefore we'll see case to case and then see,
No.
it's impermissible. 1 minute, let me just complete. And in section 7, there is a scope. Section 7 talks about 3 stages. Stage number 1, pre-agreement. Second is during the process of agreement. And third is thereafter. In these 3 stages, if something can be considered akin to a party who is a signatory, it provides, to that extent, it is permissible. The principle of fluoro control can be seen. If you see each of these sections.
A, C refers to a document. B refers to exchange of letters, etc., etc. C is a clear indication that can be post-contract also, when disputes are
Pleadings.
Because when you file a statement of claim and a defense, that is obviously after the dispute has arisen. Therefore, it is post-dispute. So an arbitration agreement can also be implied when it's in writing, arising from the fact that it is asserted by one party and denied by the other in a claim and defense.
Correct.
It is after disputes have arisen between them. So one thing is very clear, that the arbitration agreement does not always have to be a pre-dispute arbitration agreement. It can be a post-dispute arbitration agreement also.
So let me, I'm grateful.
And also just focus on later on, I mean, I just raised it, just for the, otherwise I forget it myself. Section 91 will really affect us because
Yes.
91 or 92 of the evidence act.
Therefore, let me.
But obviously you have to give us a little bit of a statutory handle to conceptualize and formulate. Now
Next.
it's for a
Straight away. Now, let me just summarize in the light of these questions.
I mean, very learned authorities have supported the doctrine. I mean, they know what, but I mean,
Why your lordship
now
should not
interpreting Indian laws.
have any doubt about the fact that the statute does not inhibit it. That's what I'm now addressing. Statute will not inhibit or prohibit or stop us in any way.
Does it by the words which are used in section 7 inhibit or stop it?
Answer is no. There should buy. There should buy. The real question is when come to the word parties is used right through the act, everywhere, including 7, 2H, etc. 8. Parties. Question is, was the intention ever to limit parties to signatories? If your lordships, brothers, cannot look beyond the signatories, then, brothers, look at the 3 underpinnings of the development of this law.
Yes.
The 3 underpinnings of the development of the group doctrine are already available and they provide a sufficient safeguard. And now justice is only a trigger for your lordships to go and look at that direction. It's not at all the determining factor. What are the 3 underpinnings? And that is the best answer to your lordship query, in my opinion, which gives your lordships a restraining field. First, and many of them are in fluoro and some are in the later judgments. First, there must be a interconnection, a group which is clearly visible, heavily interconnected in the negotiation and implementation of the contract, performance of the contract. 90% of your lordships, brothers, fears and anxieties about other cases will go out of this test alone. Should be a very closely, this is the first test of fluoro actually, interconnected group, not in the abstract sense, for that contract, for that performance, for that refinery project, for that building. I'm not saying whether that otherwise interconnected with his parent company in USA. For that contract and performance, they have to be interconnected. Number 2 condition, there has to be a mother agreement with an arbitration clause. And your lordships has to find it to be a mother agreement, not my say. How many cases your lordship will not be at all?
So there
has to be a mother agreement.
So 2 conditions you say. There has to be
third.
connection.
I'm now making it.
Could you just formulate it once?
Yes.
Just,
First is the group doctrine is based on a set of highly interconnected entities associated in the negotiation and performance of the contract, of that contract, I would say, not in their own headquarters.
Associated in?
A set of interconnected entities associated in the negotiation and or performance of the contract.
Associated in making and performance of contract.
Of that particular contract, yes.
Thank you.
Each of the points I'm moving, we get the pattern ready.
Forgot this. So you said the group doctrine is based on a set of highly interconnected entities associated with the negotiation and or performance of the contract.
Or as my lord put it, making and performance.
That's the second one.
Same thing. Second, your lordship has to find what is called a mother agreement. It is your lordship's finding that it is a mother agreement. 2. That will also be called 2A. And 2B will be that mother agreement has to have an arbitration clause. This itself whittles down the concept of abuse. I'm not going to suggest that your lordship goes into a justice inquiry straight away. Now, third, this mother agreement with an arbitration clause must give birth to or spawn progeny agreements, one or more. This mother agreement with an arbitration clause must give birth to or spawn one or more progeny agreements. Number 4, the progeny agreements would not have an arbitration clause, otherwise the issue will not arise. It may be one of them out of 4 has it, 3 of them don't have it. That also happens. These are progeny agreements, no arbitration clause.
The progeny agreements will be between whom? The claimant and the third party, or this defendant is the third party?
Now, what is happening in this case?
Can it be completely unconnected to the original parties?
No, these are all with the project. No, I'm not. I'm saying everything with the project. I'm sorry, I didn't add that. Both the mother agreement and obviously, I'm sorry, the first sentence said so, I did not add it. Both the main mother agreement is quite the project only. We are talking only, that's the point. Your lordship has somebody sitting in America doing other projects with the mother agreement, we are not concerned.
Right.
Mother agreement without arbitration clause, quit the project. 4th, in the context of the dispute arising, this will be post-dispute. These 3 are not enough. 1, 2 and 3 or 4, I can't come to your lordship and say, send me to arbitration with that mother agreement chap. I'm sorry, with the progeny agreement people. This is the other cumulative condition precedent. After the dispute arises, your lordship should have some finding that it is necessary, which includes justice, to read all of them into a common arbitration. That is a supra-added condition. It's not merely the existence of the first 3. There must be a necessity based on a sense of justice or injustice. So it's the reverse, it's the last. It's not the trigger for the actual finding. Now, let me complete this. This is only the next point related to the query. Very good. Into this, your lordship has to weave the extent, if any, to which your lordship is prohibited or inhibited by the Act. The answer is simple, unless your lordship is forced to read parties to mean signatories, which would be a completely wrong interpretation. Your lordship is not inhibited. So long as your lordship does not accept the proposition that parties must be signatories, which cannot be the law, according to me, then your lordship's inhibition in all sections goes away. It is because the subtext of every submission on the other side has to be that parties in some sense, not quite adumbrated, means only signatories, that this problem is arising. Next. The next aspect, I'm very pointedly answering this part, I'll be again expanding and go to the case law ones. Next aspect. 91, your lordship need not be worried about. 91 is a straightforward provision which says, a contract says, I must give you black and I must do it in 5 days.
You can't vary the terms.
I cannot get him as a witness and say that it can be a shade of grey and it can be 4.5 days or 5.5 days. That's all. Now, unless your lordship, which cannot be again, is told to construe 91 to mean that the contract says singvi, but your lordship is applying arbitration to Rana. That also technically is 4.5 days and grey.
You can
That's not the way your lordship looks at it. It can't be Malas that I have signed it and Mr. Rana here is Malas not technically, his name is not in the contract. So Malas, 91 your lordship may keep out altogether, your lordship may rest assured there will be no bar, no inhibition, no problem of 91. And it is in this sense that actually I am putting justice against me. I am very grateful for my Lord's query. I am not putting it in my favor, I am putting justice point against me. Suppose my Lord finds all my points cumulatively in a case, but does not find the necessity of the justice to do it. So it's a supra-added point. Your Lordship must need to do it to effectuate justice in that context. That's how I meant justice. So actually it's a point against me if at all, or at least it makes the threshold bigger against me. Next issue. These are not a matter of teleological, it's a matter of your Lordship's judicial policy interpretation. For something like this, which does not fragment adjudication, fragmentation is a very important thing. Your Lordship needs a specific bar in the statute. Well, it's so easy. Suppose the Lordship's constitutional bench comes in an extreme manner. I'm not saying, I'm just saying, take an extreme judgment. Everybody will design contracts to make the adjudication and arbitration meaningless. The adjudication, the arbitration is meaningless because I have to file one arbitration, win something, file a second one, third one. Fragmentation is a complete The other phrase which goes with my first point of integrity is composite transaction. Remember, all my principles are for a transaction. I'm not repeating it. It's a very important point made by Justice Narasimha. I'm not suggesting general relationships, that project, that contract, that composite transaction. That's the point.
In modern world, most of these contracts leading to multiple arbitrations and all these are invariably composite contracts.
Which is why,
Building of an airport, DMRC, whatever it is.
Grateful. Why, because in the same group, your Lordship has a construction expertise company and a design expertise company. And sometimes they may not know each other. They are making the same airport. One is liable to arbitration, the other one goes in a suit. It is therefore no coincidence that this doctrine has come to us from abroad. We are not the inventors. They invented it earlier in other countries because they had these kind of contracts my Lord is mentioning now. They have been using this doctrine. Three phrases, will really intermesh and intersect. Interconnected, composite transaction, and sometimes it is called single economic entity. It is certainly not single economic entity, but in a technical sense. The mother company and the progeny. It can't be literally called a single economic entity. Why is it called like that? So much of material has the same phrase. Because your Lordship is ultimately looking at the core. In a technical sense, no. And these 5-6 conditions will take care of the very, very important aspect underlined by my Lord Justice Narasimha. Public law. This public law, your Lordship judicial review is massive. India has judicial review for decades, which would make Marbury and Madison blush. For decades, not now. That judicial review in public law domain, your Lordship is, if your Lordship were to bring an inch of it into this, it would be a revolutionary thing. Not even an inch is coming here. So your Lordship is rightly demarcating this public law, private law spheres, where although sometimes there are other issues of maintainability of writ, the Lordship has mellowed it down, but we are not concerned with all that. Your Lordship need not, I'm now trying to assuage an anxiety, a potential anxiety, that your Lordship will bring in public law remedies or public law concerns. No, your Lordship will not.
Much of what you have indicated,
yes,
can possibly be constructed and read into Section 7 itself.
Now, that exactly. Allow me. There is not a single word which I have said which cannot be read into and is consistent with 7.
Only B.
Come on, tell you.
That is your section E, I think, right?
Once your lordship, once your lordship accepts parties is okay. Once your lordship accepts parties is not signatories. But let me give you a simple example. Because I am doing a project of a bridge. I have emails from 3 foreign people, all part of the same group. But one is design, one is construction contract. I have a heavy email inflow and I write to all 3 of them. Ultimately, your lordship fructifies in one contract with one of them, which has an arbitration clause. But the exchange between me and those 3, design this, design that, construction this, load factor that, etc., with 3 companies, part of some larger group for that particular project is very heavy. Would it not come under B? Ultimately, the arbitration clause is limited to 1.
This group of companies, the example that you gave is actually a good example. Let us say a very major project, airport.
Yes.
You have the design person coming in, providing the design, somebody is constructing, and somebody is executing maybe also additionally. Now the design person may be part of the same group. It is one contract, you are talking about the airport. The design person has given the design on basis of whatever value he charges for providing the design. But then beyond that, he's not involved with the contract. Although his design is being utilized for the contract. Now, so far as the design company, Progeny contract, does he come in?
Straight away. With your lordship example, remember, we are talking of dispute resolution, not merits. We are talking of suit versus arbitration. That's the only issue today. In this example, just add 2 sentences, the bridge collapses and the report finds it's a design fault.
That is culpability. That is culpability.
No, I'm saying dispute arise.
Dispute arise. All right.
I file an arbitration against the signatory. Get this design fault worked out of the arbitration. Should I file a suit against him?
But he is providing the design to the executor of the contract, the person who has signed the contract, and he has brought forth that design.
No, if he is not a separate entity, then the issue will not arise. Then it's enough to sue that man. If this person is subsumed, well, suppose I am the owner and he's the builder of that airport. Within his, there's a department which does design.
No,
Then if it's a separate entity, then this arises.
No, that's right. That within that, executor of the contract department, they would definitely be part of the.
They'll be covered by, if I sue him, I sue them.
That's right.
Yes. However, if it's the sister concern, let's use
Sister concern,
loose word.
Loosely, yes.
Word. We don't know yet why it's never called a brother concern, it's always called a sister concern. But anyway, his sister, this is a reverse gender neutrality. There could be an objection on this for us. But sister concern directly involved. The fault is both of that person who does it and the person who does the design. Then this is fragmentation. Exactly the query by Lord is putting is the fragmentation issue. Incomplete justice, fragmentation, injustice. Exactly.
Should there be separate proceedings for such an issue?
Because
That's
you're
what you are
only
asking.
considering dispute resolution, not the merits. Who will win is not the issue. Whether the culpability is right or wrong. What is arbitration, brothers? They have chosen to arbitrate to keep away from court. In this case, it will be international arbitration even more.
Singh, would you like to now go to E, your section, E in your written submission, because that
Without going to
incorporates-
E, you should just keep the act in your hand. It is E only. Just keep
Yes,
the
sir.
act. Because that's really the very, which in a
That's
sense
the
was
crux of the
anticipated.
matter. That's the
So,
crux of the matter.
So we'll just see. Well, according to me, what I've said, I can't improve on what I've said, the 7 principles. But for this 2(1)H, if your lordship does not limit to signatories, the whole problem is solved.
Right.
Of course, I don't limit to signatories.
7 is clear, it can't be.
Only 7, 2(1)H. Unless your 7, I have made my submission, my lord has noted it. Unless your lordship is compelled to interpret and limit 2(1)H to signatories. I substitute the word signatory for party, which fellows can have very alarming results.
It can't be because
Yes.
party is defined in terms of.
I am very grateful.
Agreement which is in 7.
I am very grateful. Even otherwise, fellows, look at your lordship is trying to limit some doctrine. Rightly, in that process, your lordship will have to look at the other consequences, fellows. If it's only signatories, this design example was giving me a design in delay, performance problems. Have a quick run through the act. There are 5 sections I've identified. I may not be correct, but there may be more. Lordship may have in mind. The 5 I've identified. Just see 2(1)G before that. Now, this is not about the subject matter today at hand.
Legal
I'm
representation.
only by analogy. And I've dealt with 2(1)G at page, at E1 and E2. Don't go to it, just note the paras, E1 and E2. 21G is another form of expansion. Of course, the object is salutary that if the main person dies, the LRs, the arbitration doesn't end. So 2G, but it's a form of expansion. 21G goes with 40 minutes. This word in 21G is in 40. So whether if the main so-called party dies, it's not relevant for today, I'm giving an analogy. Now, 21H, I have said, is a much wider meaning. My Lord Narasimha has just underlined a particular facet which I've already mentioned earlier, but you should keep that facet in mind. Then comes 7, which we have discussed in some detail. This is all covered in E1. This is all part of E. And then 8, the amendment. Now, I have run out of sections after this. 21G, H, 7, 8, and 40. Now, you cannot now be asked to create a section which is some kind of an imagined interdiction of your lordship's power. Which is that other section? For that matter, which is that particular object of the Arbitration Act, or even I will go behind to the Travo Preparatoire of the UNCITRAL, which suggests that your lordship should limit it to signatories alone. The best of my knowledge, nothing exists. The 5 sections which I have found are these ones, which can be construed this way or that way, some expansion, some inhibition. My Lord has already discussed the basic one, actually only 2, H and 3, H, 7 and 8. H, 7 and 8. 1, H, 7 and 8. So, if your lordship has a doctrine in Indian jurisprudence and earlier recognized in foreign jurisprudence, today the question is how much more your lordship will curb it without an actual limitation in the act. Should your lordship curb it and how much? Of course, technically I should have mentioned 45 also. It doesn't arise. So in technical.
Of an affiliate,
The
the concept of an affiliate is also brought in the 5th schedule, a completely different context.
Yes.
Where the issue of justifiable doubts as to the integrity or
Correct.
Yeah.
Correct.
The item 5.
Correct.
5.
So she will add 45 and the 5th schedule.
Is an affiliate of one of the parties if the affiliate is directly involved in the matters in dispute in the arbitration.
That's what I should have said it.
Context.
I should have said it. It's a point in my favor if your lordship at all is looking for expansion. Not that when your lordship has bias and conflict, this should be an affiliate approach. But just saying, there is that expansion also. 45 I have not mentioned, 5th schedule I have not mentioned. The lordship may want to for completeness add. 45 is obvious.
Many of those judgments have relied on eight, but eight
Eight is
is
not
a
there.
little problematic to rely on eight. Because eight is the power of the judicial authority, number one. And secondly, that party or somebody, any person claiming through him may apply. But that expression will not lend to who the parties are and expand. I mean, you can't
I
do
bow
that
down.
reverse,
It
that
is,
reverse engineering can't be
it
done.
is,
But expansion can be done, of course, on the basis of section seven
Section
itself.
7.
well, I bow down. It is my case that 8 is the least of my juristic basis.
But most of the judgments have
relied
relied on it.
2-1-H and then
Whereas non-signatories, no, on common law.
7.
Whereas common law is as well a part of your lordship's binding law unless the statute nullifies it. Common law, which has these conditions preceded, which have already limited it, they are the better basis. Mother agreement, same project, progeny agreement, one has arbitration, others don't have arbitration. What is wrong with these principles? Statute doesn't say it. Do they become, does a non-statutory common law become bad for any reason? 8 is the least of my bases. Even in my note, I put it for completeness.
Yes.
But it's the last. 8 is an additional point.
Because of 45, chlorocontrol dealt with 45. Then
Yes.
came the law commission. Law commission said amend it.
No, because much was made of
8 and 45
yes,
seems to be out.
also much was made of 2-1-H. And
Right.
why was it not correspondingly amended and all that? That's why we put it there. I would say, the common law reasoning, which is a automatic inbuilt public interest limitation, is sufficient. It is for them to point out an inhibition. It is not for me to point out an affirmation. This is whole case is, if I may say so, the approach is a little bit skewed as far as the rival arguments are concerned. It is for me not to point out an affirmative basis. It is there in the common law. It is for them to point out an inhibition
Right.
or a prohibition. Now come to Olus Chloro straight away. See that common law creation. Just 2 or 3 portions of judgments are important. Come to CL1 at page 63. 62, I'm sorry.
For your compilation.
Compilation 1, CL1, case law 1, I called it. And not CJ1, it was called the last case.
Compilation one.
And
Para 71 at page 62. is chloro. Actually, yeah.
We're reading para 71.
Of chloro at page 63.
Yes.
Sorry, 62. My apologies. 62.
Page 62, para
71.
correct, correct. We have
Even factual parameter mother unit is described properly. Though there is a chart there. This page, just mark this page.
Okay, of course.
Though the scope, this is well, it's just flag 62, but I forgot to say one factual aspect at para 11 at page 43. I'm sorry to jump us. Just that one chart is necessary to give a lot of flavor and then come to 62. This is at CL1 page 43 in the same judgment. This gives you a graphic idea of how the case arose for us. Dispute balance with these various companies, including number 2, 3, and 6 in that chart. In fact, whereas the hottest one was with 6 and 2, both of which didn't have an arbitration clause. And your lordship gets the mother agreement in item 1. This is actually the best way to illustrate the practical dilemma of a judge who is told that only signatories will be looked at, the others are not to be looked at. This is one of the very graphic examples. It is in this sense that I mean justice as a supra-added condition at the end. I don't mean a lordship embarks of justice straight away in a broad sense. Now come to 62. Para 71, page 62. My lord has got yes, no in the last column at page 53. 3 yeses and 3 noes. Though the scope of an arbitration agreement is limited to the parties who entered into it and those claiming under or through them, the courts under English law have in certain cases also applied the group of companies doctrine. This doctrine has developed in the international context whereby an arbitration agreement entered into by a company, being one within a group of companies, can bind its non-signatory affiliates. The real operative phrase is non-signatory according to me. Once that is sufficiently covered, then the act is not a bar. Non-signatory. Non-signatory affiliates or sister or parent. If the circumstances demonstrate that the mutual intention of all the parties was to bind both the signatories and the non-signatory affiliates. This will mark the word mutual intention. This theory has been applied in a number of affiliation arbitrations so as to justify a tribunal taking jurisdiction over a party who is not a signatory to the contract containing the arbitration agreement. Russell, a very much more conservative jurisdiction was England, very much more conservative. This involves the principle that a non-signatory party could be subjected to arbitration provided these transactions were with group of companies and there was a clear intention of the parties to bind both. the signatory as well as the non-signatory parties. In other words, intention of the parties is a very significant feature which must be established before the scope of arbitration can be said to include the signatory as well as the non-signatory. Why is this not a sufficient? Your Lordship is finding intention in every case for us, searching for it. This is a very good limitation. It is not a jungle rather where somebody has come and says group, and a Lordship embarks on group piercing. Lordship examines the intention. That's the right way. This is a very strong safeguard. A non-signatory or a third party could be subjected to arbitration without their prior consent, but this would be only in exceptional cases. The court will examine these exceptions from the touchstone of direct relationship to the party signatory to the arbitration agreement, direct commonality of the subject matter, and the agreement between the parties being a composite transaction. All this is required, composite transaction, interconnected. The transaction should be of a composite nature where performance of the mother agreement may not be feasible without aid, execution, and performance of the supplementary or ancillary agreements. For achieving the common object and collectively having a bearing on the dispute. Besides all this, the court would have to examine whether a composite reference of such parties would serve the ends of justice. In this sense, I am as an aid, reinforcing. Certainly not as a standalone. Once this exercise is completed, the court answers the same in the affirmative. The reference to even non-signatory parties would fall within the exception of that clause here. Suppose I have read this sentence to 2(1)(h) and 7. Because all problems very hardly applies and safeguards apply. It is harmonious. You will not have no inhibition. Then let us come to 76. Very good one.
The concept of the mother agreement comes in 74.
I'm grateful. May I? Mother agreement is mentioned in 73. Now let us at Placetum C. Let me read 74. I'm grateful. In a case like the present one, where origin and end of all is with the mother of the principal agreement, I'm grateful. The fact that a party was non-signatory to one or the other agreement may not be of much significance. The performance of any one of the agreements may be quite irrelevant without the performance and fulfillment of the principle of the mother agreement. Besides designing the corporate management to successfully complete the joint ventures, where the parties execute different agreements, but all with one primary object in mind, that's the airport. The court would normally hold the parties to the bargain of arbitration and not encourage its avoidance. In cases involving execution of such multiple agreements, two essential features exist. Firstly, all ancillary agreements are relatable to the mother agreement, not a standalone. Progeny has to have an umbilical cord, very strong umbilical cord. And secondly, performance if one is so intrinsically interlinked with the other agreement that they are incapable of being beneficially performed without performance of the others or severed from the rest. In exceptional cases, I am conceding, you have to even sever in exceptional cases, where it is totally unrelated. It's a temporary contract without arbitration clause for one is providing a car in the first 3 months. Nobody is saying that will also go to arbitration. The intention of the parties to refer all the disputes is one of the determinative factors. So 74, I'm very grateful, very important. We may notice that this doctrine does not have universal acceptance, but they have discussed other jurisdictions. Can I come to 76 please?
Yes.
The court will have to examine such pleas with greater caution and by definite reference to the language of the contract and intention of the parties. In the case of composite transaction and multiple agreements, it may again be possible to invoke such principle in accepting the pleas of non-signatory parties for reference to arbitration. Again, the word is non-signatory. Where the agreements are consequential, another very important test. And in the nature of a follow-up to the principle of mother agreement, the latter containing the arbitration agreement and such agreements being so intrinsically intermingled, mark the word, intrinsically intermingled or interdependent, that it is their composite performance which shall discharge the parties of the respective mutual obligations. This would be a sufficient indicator of intent of the parties to refer signatory as well as non-signatory parties. The principle of composite performance would have to be gathered from the conjoint reading of the principal and supplementary agreements on the one hand, and the explicit intention of the parties in attendance. First, just 30 seconds diversion. Justice Roy asks, suppose there is heavily interlinked in composite, but the clause which says no, you shall not touch the other components. The conduct and the nature will prevail, not that exemption clause. Then, Manas? That's all. Now, Manas, I don't think I can need to read it. Come to 103 for a second, Manas. 103 is page. Page. 74. Giving us juristic theories to justify the doctrine. In fact, may I read from 102? It's very interesting. The learned authors from 101 onwards, all brothers recognize that there could be a doctrine like this. Muster and Boyd is 101. I'll not read it. Muster and Boyd is there. Then 102, brothers, is joinder of non-signatory parties to arbitration not unknown to arbitration jurisprudence. Even the ICA's guide to interpretation of the 58 Convention provides for such situations, stating that when the question arises as to whether binding a non-signatory to an arbitration agreement could be read as being in conflict with the requirement of written agreement, the most compelling answer is no. Various legal bases may be applied to bind a non-signatory to an arbitration agreement. Now they come, the Supreme Court of India says this is the legal basis. The first theory is that of implied consent, third-party beneficiaries, guarantors, assignment, and other transfer mechanism of contractual rights. This theory relies on the discernible intention of the parties and to large extent on the good faith principle. They apply to private as also public legal entities. Second theory includes the legal doctrines of agent principle, relations, apparent authority, piercing of veil, called alter ego, joint venture relations, succession and estoppel. They do not rely on the party's intention, but rather on the force of the applicable law. The Canadian case is noted. 105, we have already discussed that under the group of companies doctrine, an arbitration agreement entered into by a company within a group of companies can bind its non-signatory affiliates if these circumstances demonstrate mutual intention. That's the basic test. Then let's come to 107. If one analyzes the above cases in the author's views, it becomes abundantly clear that reference to even non-signatory parties to an arbitration agreement can be made. It may be the result of implied or specific consent or judicial determination. Normally, the parties to the arbitration agreement calling for arbitral reference should be the same as those to the action. This general concept is subject to exceptions, which are that where a third party non-signatory is claiming or is sued as being directly affected through a party to the arbitration agreement, and there are principal and subsidiary agreements, and such third party is signatory to a subsidiary agreement and not to the mother or principal agreement which contains the arbitration clause, then depending upon the facts of the given case, it would not be possible to say that even such third party, it may be possible, my apologies, to say that even such third party is referred to arbitration. What is wrong with this, fellows? What is so anathema in Indian statute to this? Then let us come to Charan, which is
Dr. Singh, is there any judgment which you would have seen is a little off the mark? Goes a little overboard? More or less, every of these subsequent judgment perhaps is in line with Cloro. But is there any judgment? Because there's no point in reading judgments which is more or less in the same principle. But if there's something off the mark which you can...
It needs correction or comment or the streamline.
Is there anything?
There is some paragraph which is completely of the against which they can correct the constitution. I just revered. Now let us come to Charan, which I had the pleasure of arguing at 162, same volume. Facts are different, but the principle are. Facts are very different, as I said, the proxy set up afterwards. Page 158,
Yes. 158.
158. Para is 23.
This is the example which he gave.
Strategy of picking up the Chief Justice's judgments only, right?
The problem arises sometimes when he's writing a lot of judgments. That's the problem. So there are plenty here which are not by him also.
No.
Coming up.
Occupied field we are just discussing.
Yes. But what is the best answer to this was given by Justice Chennappa Reddy, who told me that I have been waiting for an opportunity to overrule myself. In a constitution bench, a lordship has an option.
Yes. Justice Bhagwati did that in the section 80M, if you remember. 80M of the Income Tax Act. It came on review and he said he overruled his view.
Lohiya machines.
Lohiya machine, when you say, maybe.
Yeah. Lohiya machine there.
23 Manas. As the law has evolved, it has recognized that modern business transactions are often effectuated through multiple layers and agreements. There may be transactions within a group of companies. The circumstances in which they have entered into may reflect an intention to bind both signatory and non-signatory entities within the same. That's the simple principle, Manas of Toro. Reflect the intention to bind both signatory and non-signatory parties. In holding a non-signatory bound by an arbitration agreement, the court approaches the matter by attributing to the transactions a meaning consistent with the business sense which was intended to be ascribed to them. Therefore, factors such as the relationship of a non-signatory to a party, which is a signatory to the agreement, that is one test, the commonality of subject matter, and the composite nature of the transaction weigh in the balance. What is wrong with your enough safeguards? The group of companies doctrine is essentially intended to facilitate the fulfillment of a mutually held intent between the parties, where the circumstances indicate that the intent was to bind both signatories and non-signatories. The effort is to find the true essence of the business arrangement and to unravel from a layered structure of commercial arrangements. Very important word for this. An intent to bind someone who is not formally a signatory, but has assumed the obligations to be bound by the actions of a signatory. Then my Lord touches on uncitral. Now, I am saying this is already answered. Unless I should find something grievously wrong with this, there is no reason to reconsider this. Non-signatory uncitral is discussing. Section 7 is discussing. May I read 24 also, although I want to read 25, read 24. International conventions as well as uncitral model mandate that an arbitration agreement must be in writing. 7 affirms the same principle. Why? Does the law postulate there should be written agreement to arbitrate? Reason is simple. Agreement to arbitrate excludes the jurisdiction of national courts. Where parties have agreed to resolve their disputes by arbitration, they seek to substitute a private forum for dispute resolution in place of adjudicatory institutions. According to Redfern, the requirement of an agreement to arbitrate in writing is an elucidation of the principle that the existence of such an agreement should be clearly established, since its effect is to exclude the authority of national courts to adjudicate upon disputes. Does the requirement, as in Section 7, that an arbitration agreement be in writing, exclude the possibility of binding third parties? This is was directly answered by Lordship, the query Lordship asked me in the morning. Now, it can be wrong, you are a constitution bench, but what wrong is pointed out to us here? Directly the same question. Does the requirement as it, I'm sorry,
We'll come back after.
Yes.
How long will it take now?
About half an hour, 40 minutes.